A very good evening, everyone, and hello to all of you joining us this evening for our webinar session on Living a Legacy, how will writing can benefit you and your loved ones. Now, for today, we have a very exciting arrangement where we have a guest speaker together with our own in-house master trainer. We will be going through today's webinar session. And I hope for those of us who have joined us early this evening, I hope you have all had your dinner and you are ready to go listen to us for this evening's topic. It's going to be a pretty interesting topic, I believe, for most of us. Always a very firm crowd favorite when it comes to talking about estate planning matters, will writing. So hopefully tonight's session with the expertise of two industry veterans, I believe we will be able to learn quite a fair bit of information tonight. Now, in order for us to get started, I understand from my registration team that today we have quite a number of attendees who are new to MoneyOwl. So welcome, and allow me to introduce who MoneyOwl is for a quick couple of minutes, and we will proceed on with the webinar proper itself. Yep.
Ever wondered what your golden years will look like? Will they be filled with toil and stress, or choices and meaning? If you're aiming for the latter, here's what MoneyOwl can do for you. We'll help you make wise financial decisions to reach your retirement aspirations. Our financial advisors are fully salaried and don't earn product commissions, which means you'll only be recommended affordable and fit-for-purpose solutions. As Singapore's first bionic financial advisor, you'll get the best mix of technological and human capabilities to give you the financial help you need. To us, being wise about money is about having a sensible and balanced outlook on life. In other words, life decisions before financial decisions. That's why we take a holistic approach to your financial planning so you can retire well. We can help you check your financial health, protect your income from life risks through insurance, grow your wealth through investment, and get that passive income you've always wanted. Optimize your CPF and project your retirement income from it. And write your will to ensure your loved ones are taken care of. You can either do a comprehensive plan with us covering all these aspects, or access one of these services directly. It's never too late to begin your journey towards a fulfilling retirement. Head over to moneyowl.com.sg or call us to get started on your retirement goals today.
All right, that was a quick video introduction of MoneyOwl, and I hope that that gave us a quick insight to what are some of the services that is provided by MoneyOwl. I haven't introduced myself. For those of you who are new to MoneyOwl, my name is Albert. Together with me tonight, I have Master Trainer at MoneyOwl, Felicia, and I also have our guest speaker, Mr. Patrick Chang, who will be bringing us through tonight's topic. As more and more participants are streaming in, once again, I just want to warmly welcome all of you. And as I continue the sharing of who MoneyOwl is as a quick introduction for some of you who may be new to us. So we are Singapore's first bionic financial advisor. As said in the video, we are a marriage of the best of human advisory and also technology, right? And we bring financial advisory to the common folk, right? The working adult, you and I. And the core of it is that we want to bring a conflict-free advice through taking out the commissions, and we have fully salaried client advisors. So all the staff at MoneyOwl do not take commissions, and you can be assured that in the event if you need to take on any of our services, we will only be recommending solutions that are fit for your purpose, right? And really, at the end of the day, is to help us stretch our dollar as well. And we are also an NTUC social enterprise, right? So In the area of helping you stretch your dollar, I also want to share with all of us that tonight we are also having an ongoing promotion to encourage all of you to start thinking about maybe considering writing your own will, right? And at MoneyOwl, we also do have a simple will writing service, which we will be happy to share more in detail later on this evening. So as we can see, as an NTUC social enterprise, there are many other social enterprises under the NTUC social enterprise umbrella as well. And each of them, they do serve a very specific purpose, ranging from your groceries to your food and beverage, early childhood education, and adult continuing education as well. And MoneyOwl really is just here to fill a gap in the financial advisory space. And we are we have a very good platform that is currently online, right? And I encourage all of us to visit our website at www.moneyowl.com.sg and have a feel for yourself and get to know us a little bit more, maybe after tonight's session as well. So without further ado, I will very soon I will pass the time over to Mr. Patrick Chang, founding director of SimplyWills Private Limited and Advanced Planning Private Limited. Towards the end of tonight's session, we will have about 15 to 20 minutes time for Q&A, and I believe there will be many questions that all of you in the audience today may have on this topic. So I encourage all of you to share your questions with us, either through chats to one of my team members or myself, or later on, we do have a platform which we'll be using Pigeonhole for tonight, right? And I encourage for those of you who do have questions to take this opportunity to consult the expertise of two industry veterans tonight. So without further ado, I shall pass the time over to Mr. Patrick Chang. Patrick, over to you.
Right, thank you. But let me get my slides first. Right. Good evening, ladies and gentlemen, and welcome to this evening's webinar. I hope you have taken your dinner. If you have not, sorry, the bad news is dinner not included. So you can eat dinner anytime. Now, we'd like to quickly start this program. My name is Patrick Chang. Yes, let me introduce myself very quickly. This is a brief introduction, I would say. I started my career as a bank manager back in 1984. That was a long time ago, as you can see. I was very young at the time, and you can imagine how much hair I had at that time. 4 years as a bank manager. Later on, I decided to take on something more challenging.
Right. Sorry, Patrick. Can you unmute yourself again?
Oh, yes.
Thank
Sorry,
you so much.
me. All right. So I started to practice as a will writer back in 2001 after a strong calling. Yeah. And as you can see, I was never trained as a lawyer, and I need to learn from lawyers and law firms, which I did. I spent 5 years learning from 2 law firms and 2 lawyers. And at the end of 5 years, the second lawyer told me, you should go and start your practice now that you're very experienced, which I did, you know. And I started my own company known as SimplyWills in 2006, and we continued to do will writing and safekeeping for a long time until 2015, 2016, 2017, and 2018, because people start to ask me, hey, you have written the will for me, you have written the wills for my parents, my brothers, my sisters, now what? So we started to explore and realize that we need to do something more. That's the reason why I started the advanced planning in 2018 to offer more service. In fact, now the second company that I have, we offer a service such as LPA, which stands for Lasting Power of Attorney. And some of our clients also grow bigger and bigger in size, in terms of net worth, I mean. So they also need a trust to take care of special situations. And we also have a partner who can help us to do afterlife planning. All in all, Advanced Planning is a holistic estate planning company. And because of the nature of my job, I also work with law firms, lawyers. I invest in law firms, you will be surprised. And every 1, 2, or 3 years, I will see which are the better law firms that I like to invest. And last year, 2022, I identified this law firm known as Aureus Law. I invested in the law firm. I'm currently the senior manager. But because it's a small law firm, there are only 5 of us, including my lawyer, and therefore we only specialize in something very, very, very specialized, as in probate and letters of administration. So that's what I do for a living. Every day, I do the same thing over and over again. Yeah. And very quickly, just to run through with you the 3 segments that I have for you this evening. First thing first, I will introduce some of the rules and regulations, which are technically speaking law in Singapore. And very quickly also, I would like to address some of the myths and misconceptions about will writing so that we clear the doubts once and for all. Now, before we leave the webinar, I will also give you some tips and tricks so that some of us have decided at the end of the webinar to go ahead, then what do you do? Yes. And very quickly, 12 years ago, we engaged a team of 4 full-time students from Temasek Polytechnic. They were sent by Mr. Wee, my friend, to do a final year project. So I told the 4 students, I say, okay, 4 of you, these are the survey forms. Please go and ask people, at least 21 years old people, and minimum 10,000 before you come back. So they spent a few months. Yes, when they came back, they have interviewed more than 10,000 people. And we realized that 87% of the working adults in Singapore did not have will at that time. So today, I mean, I won't do the poll now, but even if today I do the poll, likely is about 87% or 85%, sometimes worse, 100%. I conduct a lot of talks, and every time I ask for hands, and I realize it is about there. Yeah. Now, if so many people do not have wills written, well, don't have to worry, really, don't worry too much. Now, in Singapore, if you don't have a valid will, then our assets, when we pass on, will be distributed according to the 9 rules. Men on the street, we call it 9 rules. Now, 9 rules, as far as we are concerned, there's a legal name to it. The actual name of the 9 rules is known as Intestate Succession Act, Chapter 146. So there are 9 rules there, but the Act, Chapter 146, also have a section which is so important, I need to highlight to you this evening. Section 2 of the Act says, whether I am a Chinese Muslim, Malay Muslim, or Indian Muslim, as long as Muslim is concerned, they are not affected by the 9 rules that I'm going to introduce. This is what Section 2 says. Why? Because Muslim have Muslim law, which is known as Administration of Muslim Law Act. And therefore, if you have say neighbors, colleagues, or friends who are Muslims, I'm sorry, the 9 rules that I'm going to explain will not apply to them, but they can still look for me because my lawyer, Masago, is a Muslim. My senior legal executive, Sakina, is also a Muslim. Therefore, in our company, we have the capability of helping Muslims to do the Islamic will. If you want, we can do that. So the 9 rules I'm going to talk to you about is for non-Muslim. Please remember. First rule that say if a person passes on, leaving behind a surviving spouse, that means person married, no issue. Issue means children or grandchildren, and the person's parents also. No, just like this picture, you can see the picture. The man is married but no children, but the dark figures representing the parents cover the face. That means bye bye so the parents not around anymore. So in this case, if the man bang, okay, bang if the man bang like that, boing like that, then who gets the money? Rule number 1 say everything must be given to his wife, 100%. This is a law in Singapore, and you cannot change the law. Let's take a look at this law. I'd like to examine a little bit more. Take a look. If this man is married, no children of his own, but if this man like children, can he love or like his nieces and nephew? I also have 5. I mean, I married with a daughter. I also have 5 nieces and nephews. Now, before my daughter was born, she's the youngest of all. Now, I love all my other 5 nephews and nieces a lot. Every time their birthday, I give, very big ang pao. Now, none of the nieces and nephews, if in this kind of situation, will receive anything from the man. So that is the law. On the other hand, if this man is married and his parents already passed on, question to you is, will the man, or can the man be quite close to the brothers and sisters? Quite naturally, logically, yes. Yeah. So if that is the case, all the brothers and sisters, they get nothing. So the rule is there for a reason. It's a fix already. But if it doesn't fit your needs or suits your needs, yeah, you can always change it. Or this is one of the law in Singapore that you can change. All you need to do is to make a 3 pages will, or even 2 pages, and say, I would like to give 5,000 each to my nieces and nephew because they are quite cute. I want to give 20,000 each to my brother and sister because some of them need my help. You see, so the rule is there for a reason, not to suit your needs, and therefore you can change it. Rule number 1 is imperfect. Let's take a rule number 2 and 3. My situation is rule 2 and 3. I'm married with a daughter actually. So in this case, if this man is me, bang, like that, I gone. So 50% of my assets in single name obviously will go to my wife. And then rule number 3 will continue to say, the other 50% will be given to our daughter. Well, you ask yourself, if you are in this situation, are you happy with 50-50? Generally speaking, it's quite okay because quite fair, but it doesn't suit my needs. Let me tell you the 2 reasons. Number 1, because my daughter is less than 21 years old, and then I would not want to leave 50% of my money to a 13. My daughter is 13 years old daughter, because potentially complicated. Because who will be the people or the person holding the money for my daughter? My wife, who else? Correct? So my wife will be known as a trustee, and she's supposed to keep accounts for the 50% which belong to our daughter. Now, in future, I can't tell what will happen in the future. In the future, my daughter grows up to be, let's say, 21 years old, and then she asked her mother, which is my wife, Mommy, where are the rest of the balance that Daddy give it to me 50%? I heard from Uncle is 2.5 million. How come the day you gave me at my birthday only $250? So you see, potentially, I'm putting my wife in a very difficult position because she will have to keep accounts for another 8 years. My daughter is now 13, 8 years. No, I don't want to do that. But that's also provided my relationship with my wife is okay, no complicated relationship. Because as far as I'm concerned, if I go yesterday, I trust that my wife will take care of our daughter because we only have one daughter. So I will give everything to my wife and let my wife decide, how to handle the money. On the other hand, not everybody like to do this. There are also people who told me that I'm not going to give anything to my spouse. I want to give everything to my child. Also can. You need a will to do that. Every family has a reason of writing wills. So 50-50. Now, if you take a look, 50% to my wife, 50% to my daughter. Then if my parents are still around, let me ask you, ladies and gentlemen, how much will my parents get if they are still alive? Just because I'm married with a child, my parents gonna kick out by me. They get nothing, Asian being Asians, I'm not too sure is that what you want. For me, no. When my parents are still around, there's a lot of money. I mean, I left quite a big sum of money to my father. Of course, now that he passed on now, so I changed my will again. So as far as I'm concerned, if your parents are still around, or if you think that, you like to respect your parents, you like to give them something, please, you need a will to say so. Otherwise, there's nothing for your parents. Half go to your spouse, half go to your children. So this is for you to consider. Rule number 4, it says if the person is married, like this man, married, but no children, same, and the parents, now never cover the face, so the parents are still alive now. So in this man, bang, like that, 50% will go to the wife, and the other 50%, if both parents are still alive, then 25-25. So in this case, also quite equal, 50-50, correct? But then every family has a story to tell. If you don't want 50-50, then you what do you want? You want 60-40, can? You want 70-30, also can? You want 80-20, also can? But you need a will to say so, because if not, then 50-50, the law says so, Who asked you not to have a will? Correct? So writing will, there are many reasons. So you tell me what you want, I get it done for you. Now, sometimes single person, they tell me, yo, Patrick, I'm single, no, I'm not married, no children, no, don't have this complication. Single person potentially also can have complication. At least I say potentially. Now, take a look at this. If I'm still single, if something happens to me, now who gets my money? Obviously, the law say parents' law. Correct. If I'm still single, I mean, you look at my face. I didn't wear mask today. You look at my face. How young you think I am? A lot of people say 28. Actually, I'm not 28. 28 times 2 plus 7 minus 1, 62. If I'm 62, if my parents are still alive, they should be very they should be aged in that sense. Quite old, 80 something, 90 years old even. Now, at that age, is it possible that one of them, or both of them are unsound mind? Possible? Possible. So if I'm single, my money is supposed to give to my parents. If they are aged, then the money, if I give it to them, they can be cheated. I mean, people cheat them for the money, not for the body. Yeah, correct now. If one of my parents is unsound, or still both are unsound, that's it. The money will start there. Because some of you might think that, if one of the parents is sound, one of them is not sound, then the sound one take the money, the unsound one go and settle out, settle later. It's not like that. PAA 251, Probate Administration Act, Chapter 251 says, if one of the beneficiary or any of the beneficiary is of unsound mind, you must sort it out. Sort it out, it means the entire estate 100% got stuck there until you sort out the unsound mind. Now, how do you sort it out? This is another topic. So the family members, the next of kin, were to apply to the court to apply to be appointed as a deputy. So somebody healthy, sound mind must represent the unsound mind. Maybe the unsound mind person's children, spouse also can. So that process is easily 3 to 6 months, because I have a law firm. I know how long it takes. And the fee easily $7,000 to $10,000. So even a single person, you want to give money to your parents. Hey, ladies and gentlemen, you might want to consider making a will. Appoint somebody. It can be your brother, it can be your sister, it can even be your niece, one of the nieces or nephews. Doesn't matter. Somebody must be appointed as an executor in your will. As long as you have a will, appoint somebody, the name and IC number is there. The judge will never ask, are your parents sound or not sound? I want to know. No such thing, man. An executor and trustee is a person given the responsibility to take care of the beneficiaries. So a single person having a will written, and then giving money to their parents, save a lot of time and money. If not, if there's one unsound parents, you spend 3 to 6 months extra, and you spend $7,000 to $10,000 extra. Not worth it. I say not worth it. Can single person have children? I say yes because a single person can adopt a child, and then if those couples who are happily married, excuse me, if the spouse, let's say succumbed to accident, illness, those are widowed person. Widowed person also can have children, right? But they're called single, no? And then, wow, this is a bit more sensitive. Divorced person can also have children, do they? So if the divorced person, if the widowed person, if you adopt a child, the moment you have a child, your parents cannot kick out. Sometimes people say, no lah, my child get 50, my parents get, my parent gets 50. Not true. You look at the law, it will never say 50-50. It is always 100% to your child the moment you have a child, even adopted one. Now, in particular, this divorced group of people have to be a bit more careful, because I came across many of this already. Okay for your information I also went through a divorce quite painful. A marriage for 14 years, it didn't last. Didn't last for the rest of my life. Anyway, let me put it in a simple situation, an incident. Assuming that I'm a divorced person, and assuming that I have a child that's, let's say 5 years old, let's say if something happens to me, if I do not have a will written, all my money, according to rule number 5, must go to the child. A 5-year-old child cannot manage finances. I think you will agree with me. A 5-year-old child also need a guardian. Now, if I'm a divorced person, who will be the guardian of my 5-year-old child? Naturally, my ex-spouse, ex-wife. Now, ex-wife being the guardian, in cases, she can use the name as a guardian, go through the back door, or take the money in the name of my child. No, 5 years old. Well, yeah, of course, 5 years old, guardian, after taking the money, supposed to take care of the child, but who else should take care? How do I know? Correct. So divorced person usually they are quite particular about this kind of relationship lah, this type of finances lah. So most of the divorced person, if they came to see me, then I'll ask them. I say, okay, now do you have your own brother, sister, or even parents that you can trust with your money? So you should consider appointing them lah. So if you are not around, then your brother, sister, or even parents can help you to keep the money, ring fence your money, and protect it from your ex-spouse lah. Even the ex-spouse wants to come and take money, then your brother, sister, or parents will say, hey, why you want the money? Maybe the ex-spouse say tuition lah, education lah, medical lah, whatever, doesn't matter lah. So your brother, sister, or your parents being the trustee, holding the money for you, will help you to ring fence rather your money by asking the name of the education institute lah. Then you pay now, pay lah, or don't pay also can lah. But anyway, just to make sure that our ex-spouse doesn't lay the hands in the money lah. So this is for you to consider. Now, parents not around, the next group of people supposed to take our money are our brothers and sisters, siblings lah. So you have many siblings. Unfortunately, the law say if siblings, if you have let's say 5, 6, 7, all must take your money equally. So this equally pose some problems and challenge. I've asked many of my actual clients, single parents not around. I say, okay, how many brother and sister do you have? Do you want to give all of them equally? Some of them say okay lah. Some of them not quite okay. They want to give more to this one, less to that one, and some want to give to nieces and nephew other than the brother and sister. Nieces and nephew cannot take, unless one of the brother and sister not around. Then only that share, in this case is 1/7 share, it will go to the children of the deceased brother or sister lah, whom you call nieces and nephew lah. So nieces and nephew can take only if your brother or sister is not around. Otherwise, if all brother and sister are around, your nieces and nephew cannot take. This is the law. First thing, equally. Number two, all nieces and nephew cannot take. So sometimes when I show this slide to some of my customers, sometimes they say, oh, why nieces and nephew also can take one man? The law says so much. I don't want, because one of the nephews, I don't like his face. You don't like people's face, then what can I do? I am not a cosmetic surgeon, no? So if you don't like people's face, you don't want to give, please say so lah. In the will, we allow you to say, I don't want to give my money to so and so. Can. One of the benefits to protect your loved ones is not to give money to someone that you don't want to give. On the other hand, brother, sister, nieces, nephew not around, your grandparents will come and take your money. So if my grandparents are still alive, they are probably 110, 120 years old. Don't you think that is a little bit too old for the grandparents to come and close me and come and take the money? So I felt that this room, okay lah. I can accept no disrespect to grandparents, but I think too old lah. On the other hand, the next one is complicated. If grandparents also not around, it will flow down to your paternal and maternal uncles and aunts. That means father side and mother side. Wow, this one proving a relationship. You want to prove that you are uncle of so and so. You want to prove that you are aunt of so and so. A little bit complicated lah. You need to bring what birth certs lah. Minimum 2 birth certs lah. I think so lah. To prove. So I think no lah. Let's not make it so complicated lah. So sometimes people say not complicated. Now I show you all the 8 rules lah. You think complicated or not? Single person, they think not complicated. I think quite complicated. Finally, if nobody comes and take the money, I tell you the good news. The good news is Singapore government reluctantly take your money and keep. They don't need your money. They have a lot. But if you give, then they quite courteous and polite. They send you a letter. They say, thank you for contributing to nation building. Not bad. Now you see these 9 rules, ladies and gentlemen. Now that within the short span, I show you all the 9 rules. Now, if you think that the 9 rules is important, then you take a look which one is affecting you, because one of them affecting you, I don't know which one also. Depends on whether you're married or not married. So if you are not happy with the 9 rules, then you can change the 9 rules. The 9 rules, in my opinion, are not perfect. I say it is not perfect because there's some complication. I share with you a few potential problems. There was one of my customers, he passed on at the age of 60 something, parent passed away already, and he has many brother and sister. Now, the money must be given to the 7 brothers and sisters in this case, but the money got locked up in the bank. in personal name lockout liao ma. So the brother and sister will have to apply for letters of administration from the judge, from the court, to close the bank account. Now, who can apply? All 7 brothers and sisters, anyone can apply now. So anyone who apply, the one who going to apply, if he or she gets the letters of administration, can close the bank account, and he or she will take all the $70,000, not 10,000. So after taking the $70,000, if this administrator is less than honest, runs away with your money, all the other 6 brothers and sisters all will suffer. So potentially, if you don't appoint someone that you trust, and the administrator so happen to be not so trustworthy, then you open a can of worms already. So I don't want to take chance. I want to appoint someone that I trust to be the administrator or the executor in the will. You can see one imperfection. Now, on this day, there's this Singaporean Chinese. The man, the wife is from mainland China. Then they have a 3-year-old daughter. The man passed away. So the widow came to see me, or rather, call me, not came to see me, call me, say, I want to take my late husband's bank account, the balance. I say, can. According to the law, because you're a young child, less than 21 years old, okay, I need 2 persons. Other than yourself, can you go and find one more person above 21 years old? Must it be related? I say, better still. So her mother and the 2 brothers are staying in China. So not very practical. I said, never mind. The man's side also can. Your husband's side also can. The man's side, she has a mother-in-law and sister-in-law. But both are already quarreling with her, even while her husband's still alive. So sometimes certain people, got marginalized by certain people. Anyway, these 2 is not, they are not going to help the widow. Why? I say, then you got friends or not? Now don't know relative, got friends now. Friends also don't have. Very poor thing. Friend also don't have. Then the law never say must be related. So can I ask you one last question? Got neighbor or not? Neighbor should have, unless you're staying, I don't know what type of house, got no neighbor type. So the neighbor, so the lady neighbor was a childcare teacher. Finish work, go home, eat dinner. 8:30, I went down to explain to her. Now, this lady, if she agrees, she must hold the young daughter's 50% until the daughter is 21 years old. No? So daughter only 3 years old. No? So you think carefully. No? You put your nose into somebody's financial affair for 18 years, and you're not paid some more. So this lady, after I explained to her, reluctantly, she said, okay, who asked me to be a neighbor? That kind of situation. Then immediately, the husband of the neighbor, I said, hey, the wife, I said, hey, why are you doing all this? So the husband objected quite violently that day. So I look at the situation, I said, not so nice. Why like that? No? Why you all never talk properly or what? So I said, you sort it out before you come and see me in my law firm. I'm not coming back. You sort out, then you come and see me. So till today, when I call the widow, haven't settled. So if you have young children, less than 21 years old, my friends, for goodness sake, please go and make a will. So if the man has made a will to say, I appoint my wife to be the executor, that's it, full stop already. The wife, the judge will never ask, hey, young lady, do you have children before 21? No, below 21. No, don't have all this problem already. So a simple will helps to protect your loved ones by making the right person not going through all the unnecessary trouble. So in this case, quite unnecessary. So this is another benefit, how you can make a will to benefit your loved ones. Next one, sometimes people say that, hey, Mr. Chang, my one, I don't have a lot of assets. I only one HDB flat, 3-room flat only. Need will, man? It depends. There was one elderly lady, many years ago. So I conducted a talk at one of the CC in Mandarin. After that, she was quite shy. So after that, she put me one side. She don't have to ask questions. I said, never mind, tell me what is it. She said, my husband passed away already. This elderly lady, 70 plus. I own a house. Correct? Because HDB, usually a husband and wife with joint tenancy. So the husband passes away, then the wife will take the house. It's like that one. It's correct. So this elderly lady, 70 something years old, she told me she had 2 children. So her daughter, 50 something years old, I saw the daughter that day at the CC. I said, this is my daughter, 50 something years old. And my daughter, a few things about the daughter. First thing first, the daughter didn't have full-time job. Why? Because she is the caregiver to the mother. So take care of the mother. Also, sometimes mother need to see doctor, got to bring her to see doctor. And mother has some medical complication, too sensitive, let's not talk. And then because no fixed job so the income also not very high and because of that, also no savings saving very little and because of that, also cannot afford another HDB flat So these are the facts about this daughter. But the elderly lady has another son. This son is okay one. Okay meaning is married with children and then he got another house bigger than the mother one 4-room flat bigger than 3-room so this one is the situation. Now the elderly lady very concerned. So when she talked to me, she said, Mr. Chang, if anything happens to me in the future, who will get my house? Is it my daughter? Is it my son? Or is it two of them will get the house? The answer is both will get the house. But the daughter, the son has another house, right? HDB. Do you think HDB will allow the son to take another half the house from the mother, the deceased mother? No, the answer is no. So most likely they have to sell the house. And if they sell the house, problem, because the daughter will have no house already. Even you get 50% of the sales proceeds, so what? You cannot buy another house, another 3-room flat. Even you want to buy, the daughter wants to buy the house share from her own brother. Has she got the money? Because it's subject to refinancing loan but her income probably don't justify even justify then the bank or the lender will test your the total debt servicing ratio and then there might be stamp duty also. It's very complicated anyway. We found a simple solution to this relatively complicated situation. Later I'll share with you how I solved the problem for this elderly lady. There are many reasons why people don't make wills. So my opinion is there are some misconception. So the number one misconception in Singapore is many people still think, or even among our audience here, you think that you need a lawyer to write a will. Is it true? Let me show you the law. The law is called Legal Profession Act, Chapter 161. If you look at Section 33, subsection 10, it says, the law says you do not need a lawyer to write a will. So if the law says no need lawyer, it means no need lawyer. So what does that mean? It means you can do it yourself. Towards the end of the this webinar, you see how you can benefit from here. So you can do it yourself here. But then sometimes if your situation a bit more complicated, you want more complex, please, if you need more help, please leave the job to the professionals. Don't do it yourself because you might not have enough knowledge to do that. Now, on the other hand, sometimes people say it's expensive. Making a will is not very expensive, honestly. Anyway, even you had to pay $200 to write a will. My opinion is this. Now, your loved ones, the price your loved ones have to pay later is usually more expensive than the one you're paying now. Assuming that you say $200 and then something happens to you, you don't have a will written, and then your family members starting to fight among themselves. Where do they fight? Kitchen? Toilet or pantry? No, they go to the court and fight it out, right? So when they go to the court, we got problem. So what type of fee do you pay? Litigation. Litigation fee in Singapore never 300, never 200 cannot be. It's always thousands of dollars. So don't be penny wise, pound foolish. I'm going to save 200, and then your family member go and pay 3,000, 30,000. And worst thing is what? Family member fight, and then later on they don't call each other brother and sister already. So don't be penny wise, pound foolish. Make a will. Make sure your loved ones don't go and fight among themselves. Please. That's how you can benefit your loved ones. Something is very complicated. You attended a lot of webinar. This is maybe the 10th time you're attending such a webinar. So every time you want to make a will, you go and see people. People say, hey, please, tell me how many bank accounts you have, how much investment and insurance you have. Do you have to list everything in your will? I say no. Why? Because our assets will change over time. So you should not be writing it in the will. Because you change the will, you need 2 witnesses and a bit more complicated. But you still need to have a record of your assets. This is how it works. I make a will. I say, okay, when I die, I want to give everything to my wife. Can or cannot? I say can. Actually, I am not too sure. I wasn't too sure. I asked my wife, hey, darling, when I die, can I give everything to you? She said, can. So confirm now. So my wife confirmed, say can give it to her. So assuming I did that, something happens to me yesterday. So you think my wife knows what I have? So you are very sure you know what your spouse have lah. No lah. A lot of people don't know one lah. So for my wife to find out what I have, even she take my damn cert and go to the bank, you think the bank will tell everything? No, like that one. You go insurance company, you think insurance company will disclose everything? No, they will not. Standard answer, go through your lawyer. So for my wife, she wanting to find out how much I have. She'll be running around like hairless chicken, no? Everywhere also, kena, no? So cannot. And therefore, even among the 227 of you in this room, even you have done your will, if you don't have the list of assets, I'm sorry, your job is not done yet lah. Huh? So even you have done the will, you need the schedule of asset, which is a separate document. It's not part of the will. You don't need to sign or get two witnesses when you change the list, yeah? And then you do it yourself. Why? It's private and confidential. How much you have in your bank account, please don't tell me. I don't want to know what this. Make it complete. You have 10 items, list all the 10. Don't go and put 9, and then, one item nobody knows. And then you print it out. So then don't keep it in your computer. Nobody know your password. Print it out, put together with the will. So when we see the will, we need a list of assets to make the job complete. And then because your asset change over time, you update the list of assets periodically. Whether it's once a year, once every 2 years, up to you. No fixed answer one. Now, this is the number one reason why people want to make will. First thing first, among the family members, maybe one of them you love a lot. Can you give a lot of money? Of course, it's my money. Correct. If another one I like a little bit less, can I give a bit lesser? Also can. If one of them that I don't like because the person broke my heart before, so can I don't give? Also can. You can exclude person. Now, can you see how making a will can really benefit those family members that you care and you love? This is one of the reasons. Now, the other one, to make things even easier, so you should appoint executor. Like just now, 7 brother and sister, anyone can be executor or administrator in that case, which is risky because your brother and sister, not everybody is very honest. I mean, I don't mean to badmouth your brother and sister, but that is a fact. So my wife is the executor of my will. Now, I thought just now I give everything to my wife. Can appoint beneficiary to be executor? The answer is can. I strongly recommend. Out of the 28,000 wills that written by my company, 95% is like that one. Appoint beneficiary to be the executor. No conflict of interest because the beneficiary or the executor has vested interest in my estate or assets. So if I die yesterday, do you think that my wife will go and close the bank account very quickly? I think so. But then don't just put one name. If you can, try to put one more name. In case I travel with my wife and then never come back, then how? So I have two sisters. So I put one other sister also. So you see, will written by us, then we have 3 executors. But you want to do it yourself, also remember to put more than one. Now, just now the elderly lady, she came to see me. I make a will for her. In her will, she say, okay, when she passes, she want to give the house to the daughter. Cannot. The answer is you must satisfy the eligibility test by HDB. In this case, eligible. This daughter eligible. Then on the other hand, she has some stocks and shares, some cash she inherited from the late husband. The one balance, she give it to the son. So now both happy. Daughter get the house, okay, got house to stay. Son get extra money. So happy, satisfied. Now, CPF money cannot be included in the will. I really hope that you understand. If you're not done your CPF nomination, I strongly recommend that you look for the representative. They're all, salary based on no taking commission. Ask them to help you to do an online nomination and then guide you along. But you need help, please let us know. And the insurance policy is also quite a big ticket item nowadays. I see, over the past 20 over years, getting involved in this will writing business or insurance policy sometimes runs into millions of dollars. Insurance policy can do nomination. If you do a nomination, your nominee gets the money quite fast. If you don't do nomination, it's okay, leave it blank. But if you don't do nomination, then we hope you have a will to cover all the insurance policy without nomination. Otherwise, then they don't know how to give. Then it can be very confusing because $1 million of insurance policy sometimes can be very sensitive. People start to fight among themselves. Now, on the other hand, joint assets, you have to be very careful. Joint asset means, let's say joint tenancy house lah, joint bank accounts lah. I have a joint tenancy house with my wife, let's say. So if something happens to me, I'm older, something happens to me first, the joint tenancy house must go to my wife who is younger. But if something happened to her first, then it will come to me. If the younger one die first, then I older one will get the house. The complication comes when there is a common disaster. What do you mean a common disaster? Holiday, like now June holiday, my wife plan now, where to go. She decide one. So let's say both of us go for holiday. At Changi Airport, of course, I don't tell my wife, darling, you take this plane, I take the other plane. No lah, I take same plane lah. Same plane. Sometimes the pilot also very naughty one. Same plane. Woo! Well, the pilot never stop. The plane goes straight to heaven and report. Wow, 2 person reach heaven at the same time. They say because I'm older one, I must reach first. The law says so long, Section 30 of Civil Law Act. Wow, we die together, I die first. So if I die first, my house, I got 3 houses. My houses all go to my wife. Then I got 2 bank accounts, very big one, also go to my wife, joint account. So if my wife quietly go and make a will and say, all my money, I like to give it to my mother, her mother my mother-in-law wow, common disaster, they assume that I die first. So now my mother-in-law become the beneficiary. She got all my money if my wife make a will like that, which is a disaster in my opinion. So now you know why your mother-in-law so nice to you now. You know, I hope you know. Sometimes anyway, moral of the story, when you choose a spouse, then you choose the older one. So the younger spouse, then your will more valid for joint assets. Now, if you have assets in more than one countries, for example, most of my assets in Singapore, so I make a will in Singapore to say that Singapore will cover Singapore asset. But I have a condo and a small bank account in Malaysia also, I make a will in Malaysia, cover my Malaysia assets, So like that, it's easier, when I die, because my wife will take the Singapore will, go Singapore court. At the same time, instruct my Malaysia lawyer, Joshua Kwan, to say, okay, start the process there. So 2 applications at the same time. No complication, no confusion, cheaper, faster. If you have assets in China, I can also do it for you because my legal team from China is from Shanghai. So we can do it in Singapore. So you don't have to travel to China to do it. Inform someone that you'll make a will. Don't keep so quiet. You keep so quiet when something happens and nobody knows. But you don't have to give the will to the person. If you give already, later on you want to change, cannot take back. The person don't give it to you. Then you got problem. But you don't give people the will, then tell people where you keep. So where do you keep? You keep it in the safe place. No, which is the safe place? Oh, if you keep it in the safe deposit box in the bank, too safe. I say safe place. I never say too safe a place. So don't ever keep it there. But if you are safe at home, it's okay. This one is okay. You don't know where to keep, then we have safekeeping service. Now, on the other hand, will is just a medical checkup. Once a while, you review it periodically. And then if necessary, we write it. You are supposed to review and necessary. You can change your will. By the way, you can rewrite it. Now, this is the last slide that I have already. Sometimes people say knowledge is power. I don't quite agree. I say knowledge no power one. You don't use it, what power do you have? Use it. Tell people. Apply it. Yes. Knowledge in action is power. I agree. So today you know the law, right? A bit, because over 45 minutes. Not much I can tell. So now you know the law, right? I hope you use the law. No, if not now, part of the money I might go to your mother-in-law. No, we all love our mother-in-law. That's for sure. No, so you need to write a will to write down how much you love your mother-in-law, isn't it? Now, I really hope that what I have shared with you, you'll find writing will is an important and hopefully you also see it as urgent thing. Now, we are going to make things quite easy for you. Or in fact, you'll be surprised. And as far as we're concerned, you should get your will done as soon as possible. This organizer this evening is offering something very, very, very attractive. I believe this is something so good that nobody can resist already. So I really hope that you'll find that the session is useful. And then now pass the control back to Albert. Albert will take over from here. Albert, it's for you.
Thank you very much, Patrick. I think it was a very enlightening session, very short and sweet as well. And we have plenty of time to go. Right now, I would just like to invite to the stage, right, Felicia, our master trainer. She also brings with her about 20 years of experience in financial services industry. And incidentally, the both of us, we are also associate estate planning practitioners, right? So this is a topic that is really close to our hearts, just as how Patrick really has a very strong passion in this area as well. And I really can sense that he really has a very big calling, and I've heard him many times over as well, and every time I find it very, very interesting that he has many new things to share as well. Now, I hope that most of us have had the chance to post our questions. Let me just share the QR code again. Otherwise, for those of you who are who have issues scanning the QR code because you are maybe dialing in from your phones or your mobile devices, then you can just go to the chat, right? And click on the link that my team has shared, right? Now, I'll just, yeah, okay. So the link is being posted in the chat now. We are seeing quite a number of questions, so I'll just get my team to help me share the questions on your screens now, and we will look at a few of them, and maybe we can have some questions for us. Okay, now I think Patrick, let me give you a break after talking for quite a while, right? So maybe let me pick the first question, which I thought it was quite interesting because throughout the session, you know, people who have been listening in, they would probably be thinking about this. Okay, let me see if I can just push this up. Yeah. Seems like we have some technical issues here. Just give us a couple of minutes. Yes, here we are. So that is the first question that I picked up. And maybe Felicia, you can help us with the first question. Who should you appoint as the executors to your will?
Okay, anyone actually can act as a executor as long as they are age 21 and above, of someone and not a bankrupt. So like what we could say, most people would pick their family members. So you should pick somebody that you can trust, who can act fairly on your behalf, because their job basically is to carry out the instructions that you have stated in your will. So you must pick someone that you trust. So that's why commonly people will pick their family members, like their spouse, adult children, a close friend, or a relative. And as what Patrick has also said, your beneficiary can be your executive because there is no conflict of interest, and then they have vested interest in your estate, so they'll be more likely to be able to want to actually be motivated to act for you. All right.
All right, thank you, Felicia, for the very short and sweet answer. Yep. So really,
is it okay? I add on something.
Yeah, sure. Go ahead, Patrick.
Yeah, because you see, I totally agree with Felicia that anyone that's above 21 years old, someone whom you can trust, should be appointed as executor. And just to reinforce, I always encourage people to appoint beneficiaries to be the executor. But sometimes in situation, let's say I give my assets to two beneficiaries, 50% each. So you also don't know which one to appoint because both 50-50, right? So either one could do. But if it is not equal distribution, let's say I give 70-30, then it should be the 70% that I should appoint because the 70% have higher vested interest in my estate. Then there will be situation that I stand a bit. There will be situation that some customers they came to see us and say, Pat, I really don't have suitable individual. So is there any opinion you can give? So there are two other options. One option is really to appoint someone, even like Albert, Felicia, they mean professional people. But myself also, I'm a professional executor in Singapore. So that's provided you know me, I know you lah. Otherwise, you should not trust me because I don't know you don't know me. No, you should not be trusting me, man. Now, if that doesn't work, then we escalate to the next level. That is a licensed trust company, which I also work with some of them. So licensed trust company can also be appointed as an executor, that provided you are agreeable to pay the kind of fee lah. So licensed trust company is the safest, but it's the highest in the hierarchy. I don't usually recommend unless you need it. Otherwise, it should stick on to the basic recommendation that take the beneficiaries to be the executor. That's my take on this.
Yeah, very good point there, Patrick. Yeah, and I think I have a follow-up question, which is tying into what you mentioned just now about having a trust company to act as your executor, because they are also known as professional executors in the field. So one of the participants actually asked, can a thoughtfully set up trust replace a will? Maybe Patrick, you can share?
Sure. Will and trust are never the same. Why I say so? Because anything that you transfer to the trust does not belong to you anymore. And therefore, the will is only there to say that at the time of passing, that means upon passing, whatever that is still under your name or in your name can be distributed by the will. So when we do estate planning, we also have to be quite clear what exactly is the objective of setting up the trust. Yeah, it is common, very, very common, in fact, to have a will and a trust coexist at the same time. So anything that you transfer to the trust, forget about it. In that sense, you have no control. But in the trust setup, even the settlor, that means yourself, can be one of the beneficiaries. So it is not the same thing. Transfer to the trust take over as owner, the beneficiary is another set of people, whereas your will is controlling all the assets that is still in your name. During the lifetime, whatever that you have now, you can dispose it, you can enjoy it, you can use it, you can give it away. So nobody can stop you. But those assets already transferred to the trust cannot. You don't have the freedom or flexibility of doing it. So that's the difference.
Okay, thank you, Patrick. Right. So I am looking at one that is quite interesting. Maybe Felicia, you can help us with this. Can I give money to my pet in the will?
Well, if you can, first one, I'll give my dogs. You can't. You can only be giving it to organizations. So if you really love animals, you can actually give it to SPCA, all right, or any animal organization, those animal welfare groups, but not to pet. Okay.
Yeah, I think that is a very interesting, fun question.
It's a good question.
We get. Yeah, sometimes we do have pets, and they live with us for a long time, and they are almost like another family member. And I also spotted one other question where a participant was asking, how do we actually put a beneficiary as a charitable organization? So I guess the way that we go about doing it is to provide the UEN number of the charitable organization in our list of beneficiaries. Yeah, so yeah, that is quite an interesting question. And although we are running a promotion today, I do understand that as the questions are coming in, we have over 50 questions now. We will not be able to answer all the questions tonight, unfortunately, because whenever it comes to estate planning and will writing, typically the questions are very personal, and it is really down to your personal situation. We always have this opportunity where we can try and take this offline. Rest assured, we will come back to you with a proper response. We do not want to take it over a webinar session, Q&A as well. It might not be the best platform for us to answer these questions. So for those who with a little bit more complex right? Perhaps the simple will service that MoneyOwl has may not be the first thought that you might want to consider. And if you are looking at writing a complex will or a professionally written will, for example, taking a visit to SimplyWills and visiting Mr. Chang, right? I think the one of the questions that was asked is what were the fees? Because I think Patrick, you did not share what were the fees that you charge typically for writing a will. Yeah.
Sure. This is a general question and generic also. How much is a common will writing fee, including witnessing and executor and administrator? It really depends on who do you engage. If you don't mind, if we just go back to engaging a lawyer to write the will. Even lawyers, there are many categories. No? There are some lawyers that so-called 3-star lawyer, 4-star lawyer, 5-star lawyer. If you go to the 5-star lawyer, I'm sorry, minimum is 1,000 and above. Yeah? The 3-star, 4-star one maybe between $300 to $500. But in our opinion, I've written 28,000, my company 28,000 wills. We feel that anything that is probably $300, $400 is good enough lah. We should not be spending $2,000, $3,000 to make a will. So I would say that anything that is between $200 to $300 is acceptable lah. Yeah, $200 to $300.
Yep. Thanks, Patrick. Yeah, I think generally we also need to consider the complexity of the person's will as well. Typically, the more complex your assets, the more the costing as well, and it's just something that is related, right? I do have one question. It's a little bit specific, but it does occur to many people's mind, and typically for couples, right, there is a very high chance that they will their assets to each other, right? And what if they go on a holiday and subsequently, unfortunately, there is a common disaster, both of them die together? How will the assets be distributed?
Felicia, you want to take?
Sorry, can you repeat the question again?
It's on the screen.
Let me check. Can't quite see the screen.
Never mind. It's okay. Albert, you don't mind if I take?
Yeah, sure. Go ahead.
Okay. Now, if husband and wife will assets to each other, so my husband give to wife, wife give to husband, but both die in common accident, I will assume that they cannot tell who dies first. That's called common disaster under the definition of Section 30 of Civil Law Act. How will the assets of husband and wife be distributed in such instance? Now that depends on how the will is crafted. Because if I were to say if I were the one who crafted the will, I would say something like this: if I die first, I would like to give everything to my wife, who is younger than me. Be quite clear lah, But I will not stop there. I'll put in put a comma and say, if my wife also die with me, or even within 7 days, 14 days, or 21 days, whatever that's known as commonalities clause. Then I will change my mind. I'll say, yes, I want to give it to my wife, but if my wife die within 7 days, I want to take back and then give it to my daughter. So my wife will never receive one if it is a common disaster, because I have a substitute beneficiary. So substitute beneficiary in a common disaster situation, it becomes very useful because it prevents money from passing to one other person and then another level. Because if not, my wife has a will, I don't know who she give it to, you see. Yes, the will should be drafted in such a way to cater for the needs of common disaster. So there should be a substitute beneficiary. And husband and wife usually they will say the same. Husband will also say, the wife will also say, yeah, I want to give everything to my husband, but if my husband die within 7 days, we like to give our daughter. We only have one daughter, what? So both will channel to the daughter. So no complication if there's a common or mirror wills written for both husband and wife having or naming a substitute beneficiary. If no substitute beneficiary, it's very complicated.
Yeah, I think there's a good point there on having substitute beneficiaries. Now, let me pull out another question. Okay, now this is a little bit more specific, but I'll just put it out here. Right, so both the spouse, again, this is a common disaster, right? And they do not have any children, no other family members, but they have siblings. But I think this question is directed at the HDB, because in Singapore, most of us, we own a HDB by joint tenancy. And also, how about the joint bank accounts? Without a will, what will happen? Maybe Felicia, you can help with this question.
Okay, so for joint tenancy, let's say in a common disaster, then in the law, the person who is deemed to be older, the person who is older will deemed to have passed away first. So then in this case, if both of them do not have a will, then of course under Interstate Succession Act, and they have no children, so the husband's estate will go to the spouse, to the wife. And now to process, because the wife also passed away, so to process the wife estate, and if she doesn't have a will, then you'll be under the Interstate Succession Act. So which means to say that in this case, they have siblings. So it will go to her sibling. Oh, but these siblings is no parent. But the husband side has siblings. However, if the estate will not flow to the husband's side siblings, will only be according to the Interstate Succession Act under the wife's estate. So that is for the HDB flat. So it looks the same for bank account.
Yeah, I think thanks for the detailed answer, Felicia. Right, maybe I'll just pull up one question, which is quite interesting, I feel. What if you chose someone to carry out the will for yourself, but this person ends up to be dishonest? What recourse does the beneficiaries have? Right, maybe Patrick, you can help us with this.
Oh, sure. When we choose an executor, as I said earlier, the executor, technically speaking, should be the beneficiary, one of the beneficiary, and usually the major shareholder. If you choose someone who is dishonest, still can happen, Now, this first thing first, we have already chose the wrong person. We are not supposed to choose a dishonest person. And then the dishonest person, technically speaking, after getting the grant of probate, will be given the power to close the bank account, sell the stocks and share, and hold the money in the deceased estate account. But this executor is given the power to withdraw money. So if this executor is dishonest and took the money for himself and will still runs away with the money, and we cannot find him, then becomes a real big problem. But if it is still there, then the recourse that Benny has, beneficiaries have, is really, if I were to do that, first thing first, I like to be a little bit more amicable. If I'm one of the beneficiaries, let's say, Albert, you don't mind I borrow your name, you're the executor, okay? So I write to Albert. I say, hey, dear Albert, as far as I'm concerned, I think now already 10 months after passing of the customers, our clients. So Albert, have you done your probate? I will find out first. I want to make sure that you have done your job, and I have to make sure that you already have the money. I don't want to accuse you for doing, anything wrong. So if Albert admits that, yeah, I got the money already, then the next question I ask is, so Albert, I have a share, right? So my 30%, when are you going to give it to me, I'm going to pretend, act innocent a bit, so if you say, okay, next week, and then I take my next week, no problem, correct not? Because I got to let you know that I know that you are keeping my money, but you still don't do that, then I get my lawyer, you wait for my letter, if I can find you, you wait for my letter. But if you run away to one of the caves in Thailand, then too bad, send lawyer also no use, because I don't know which cave you're hiding in, so that's why choosing executor is so important. We have to open our big eyes, if you have big eyes, or at least open your eyes big, go and choose the executor. Otherwise, choose the wrong one, I don't know what to say, seriously.
And also, just to add, this beneficiary may not necessarily be your family loved one. It can also be like any charity organization. Because several years ago, there was such a case where an elderly lady in her will, she specified that upon her death, she wants the HDB to be sold and the money donated to a charity organization. Let's not name which organization. However, the executor actually didn't give the money. So, and the organization actually took the the executor to court.
Yes.
So yeah, so it's any beneficiary, need not necessarily, it can be a
yeah.
charity organization. Yeah.
Correct.
Yeah, I think good points by both Patrick and Felicia. When it comes to the executor, first thing is to have the person, to choose the right person in the first place, and also to consider having one of your beneficiaries, because if he or she has a share, then I think that makes more sense for this executor to carry out the duties faithfully, right? So on the topic of executors, maybe I just move over to another question asking about witnesses. Maybe you, Felicia, you can help us with this. Are witnesses important, and what if the witnesses pass away before me?
Okay, the duty of the witnesses basically is to witness the testator or you signing the will, just to confirm that when you write the will, you're of a sound mind. Okay, so as long as the witnesses are again age 21 and above and of sound mind, so just to take note that your witnesses cannot be your beneficiaries. It's a conflict of interest, and they also cannot be the spouse of your beneficiary. So let's say if I written a will and my beneficiary is my sister, for example, then my brother-in-law cannot be the witness. So there's a conflict of interest there. So let's say if they pass away before me, that is fine, because it's only the witness's duty is at that point in time that to witness me signing you signing the will.
In
Yeah, I
fact,
think that is yeah, sorry, Patrick, go ahead.
The witnesses, the roles and responsibility is not very heavy. Like what Felicia rightfully pointed out, is to see that the customer who signed seems to be in sound mind and seems to know what he or she is doing. Now, on the other hand, Section 9 of Chapter 352, the Wills Act says, even if both witnesses pass on before the testator, we call customer, the will is still valid. Now, take for example, it's only practical to put the act there or the rule there. No, you see, people like us, we have witnesses more than 12,000 wills. I mean, personally, I've written 12,000 wills in Singapore. Now, many of them are younger than me, So, wow, just because I take your $300, I cannot die before you, that doesn't make sense, right? Correct or not? So you must allow me to die. So the law allowed me to die first. So it's okay. If I die first, the will is still valid. So I'm quite safe to die. So that's the law.
Yeah, thanks for adding that in, Patrick. Yeah, so witnesses really the importance that the important role that they serve is really at the point of signing, right? They are there to witness the signing of the will. So it really doesn't matter. The law has us protected. Doesn't matter if both your witnesses are no longer around. Now, I do have a question that is quite interesting. It comes up about the MoneyOwl will template, right? I believe some of the participants are looking at our simple will and wondering if they can print out the will and add their own clauses to add a second or third executor and to add a common disaster clause. Maybe I can push this question to Felicia.
Okay, the MoneyOwl will actually already provided all the necessary clause. So let's say if you want to add on other information, then you'll probably have to seek advice from the lawyer.
Yeah, so for those who did not catch it the first time round, maybe it was not too clear. It's definitely not recommended and it will not be legally binding. As what Patrick mentioned in his sharing earlier as well. Yes, no doubt you can write the will yourself if you know how to do it. However, there will always be the opportunity for the will to be challenged in court if there are certain rules of the language that you are not too familiar with because you are not doing it on a day-to-day basis, right? Yeah. So oftentimes people like to think that it may be simple. I download a template and I just edit it here and there. And so definitely worthwhile to seek professional advice. If you really do have multiple clauses to add in, then definitely it will not be a simple will anymore. Yeah.
Maybe I just want to add on that it's actually quite dangerous if you construct your own will, because if the language is ambiguous, then it can be misinterpreted and can also be easily contested or challenged by the beneficiaries. So I would strongly don't recommend that you just download a template and then you do the own corrections. Okay.
Then I think Patrick will be out of a job already. Okay, thank you very much for that.
Yeah, so that's why if your wishes is quite straightforward, you can just make use of the MoneyOwl will, which is free of charge, really. Yeah, unless it's like something more complex, then you should then get a will drafted by expertise like Patrick. Okay.
Yeah, I have another question that I think is quite commonly asked as well, especially for someone who is not dealing with these legal terms on a day-to-day basis. They are wondering what is the difference between administrator, what is the difference between executor. So maybe I'll just pose this to either of the speakers.
In fact, they're just different terms, that's all. Administrator is being used or when a person apply for a court order to unlock the frozen assets of a deceased person. So the administrator is decided by PAA 251, Probate and Administration Act, Chapter 251, it has certain pecking order. Give you an example, if a person is married, no children, and then parents are still around, who has the rights to apply? It is the widow or the widower, not the parents. So appointing an administrator can be very tricky. Why? Because you don't have a will written. So give you just a simple example. So let's say I die. My wife will apply. Technically speaking, if I don't have a child, 50% of the money given to my wife, 50% to my parents now, if my parents are still around. But after my wife taken the 100%, she will take 100% first, then give 50% to my parents. And then if she choose not to give, then I got problem again. So administrator, without having a will, is called administrator. The person is called administrator. Very, very complicated in my opinion. Whereas the executor is used when you open your eyes, baby, or your baby eyes choose someone whom you trust to be named in your will. That the person is called executor. So it's just different terminology to express the title or the position of different person in different instrument. The power is exactly the same.
Yeah, I think that's a fantastic point there. The administrator and executor is essentially the same person. It's just whether or not you have or do not have a will. And incidentally, I wasn't expecting this, but we do have a few Muslims who are in our audience today. Firstly, I think blessed Ramadan to all the Muslims who started your fasting month this evening. And we do have a question. Can Muslims write a will? Maybe Felicia, you can help us with this question.
Yes, definitely they can write a will, and they should consult a law firm, company who has the expertise, because the Muslim will is written quite differently because it has to be written according to the Sharia law. All right. So, and the other important reason for Muslim to write a will is young children. Then you also have to decide who you want to appoint as the guardian and trustee. So I believe SimplyWills, you can also, they do have expertise in writing a Muslim will. Yeah,
we do. Muslim can write a will, but then there's certain restriction, because according to the Fariat, main Muslim law, if a person passes away without a will, then there are certain set of Muslim distribution, which is according to the inheritance certificate issued by the Sharia court. So even a Muslim doing a will, like Felicia mentioned, it is very much like to appoint an executor to perform the duty, to appoint guardian. And although Muslim is allowed to make a will to give not more than 1/3 of the assets, not to the Fariat beneficiary, but the 1/3 must be given to non-Fariat beneficiary. A bit complicated, in this platform, but Felicia is right lah. Because my lawyer in my law firm and my senior legal executive, they are very qualified people. They have written a lot of wills for the Muslims. So can look for us, no problem. Can be done easily.
Yeah, definitely. I think Muslims, all the more they should try to understand that it is important, especially when they are they identify that they are governed under the Sharia law of distribution. Yeah, and it can be something that they may not want their assets to be distributed by. And following this, on top all these questions that we have been asking is really more of the will writing, and what are some of the considerations of writing a will. I did pick up one question particularly coming from the chat. I think it was quite interesting, that was asking about if the speakers today do have any information to share regarding the government platform of My Legacy, right? And there was also a question that was similar, asking whether or not there is a place where we can keep our will in a digital form, like how we do our CPF nomination. So maybe I'll just put this up to the speakers.
Felicia, you want to go first?
Patrick, you want to do first?
Sure, no problem. So is there a central place to keep our will in digital form, like what we did for CPF nomination? Yes and no. Yes, there's a wills registry, which is a central place. Now the Law Shop is handling it. It used to be Public Trustee's office, but now it's under Law Shop, Law Society. Now, as far as we're concerned, the purpose of the wills registry is not to keep your wills. Of course, in this case, they say digital will. Unfortunately, at this point, as we speak, digital will is still not recognized in the eyes of the law yet. I cannot say that in the future. Maybe they will also consider doing this. But unfortunately, not at this point in time. Even the wills registry, the purpose is really to keep a record of someone who have a will written, your IC number, your date of birth, your name, your address, the date that you have written your will, who wrote it for you. But the million-dollar question they ask is, so who is keeping it? Where is it now? So they want to know the whereabouts. So if it is keeping at home, then you give them the address. You don't have to tell them which drawer you keep. They don't keep this record and say. But if it is a law firm, then give the law firm address. So that is the purpose. It's just to let's say, in the future when we pass, our family members not too sure whether we have a will written or not, they can, spend $10 with the deposit, go to the law society, go to the wills registry. Yeah, they will give them the records. Say, yeah, you're so and so did the will in 2010, and then the records show that it's at home there. So you go home and find So they don't have a copy. Yeah. So yes, but not very useful.
Yeah, I agree with you, Patrick, right? There currently, yes, of today, definitely there is no digital will being recognized in court yet. But going forward, we're not sure. Maybe with the digitalization, things may change in future. And on the note of My Legacy, maybe I just chime in a little bit. Currently, it is more of a resource center, right? That puts all the resources regarding estate planning in the area of will writing, in the area of lasting power of attorney, in the area of end of life planning as well. So definitely a good place, and it's a government portal that all of us can get access to. Rightly pointed out as well, the will registry does not physically store the will. However, there are will safekeeping services, depending on which law firm you go to, which professional will writing service that you go to, they may or may not have will safekeeping service. Of course, that one you need to pay for it, right? So that is something that we want to consider as well. Now, I do have one question that perhaps may affect 90% of the audience today. In the audience, the one question that came up was, can we inherit a HDB resale if the beneficiary, the person already owns private property? Maybe Felicia, you can help us with this.
You can actually, if you have a HDB flat, you can actually own a private property, but not the reverse. So let's say if you have a private property, then you cannot own a HDB property. So most of the time in this situation, they would have to actually dispose of the HDB flat and then distribute cash accordingly.
Okay, so for those who maybe didn't quite catch that, the answer is actually yes. However, it will depend on the beneficiary's current situation as well, because for Singaporeans, we can only own one HDB. So the question is not clear whether or not this beneficiary already owns his or her own HDB property. If he does, then perhaps they will need to dispose of this HDB resale property. Yeah. Now, I thought this was quite an interesting question. When you are looking at your executors, do you need to inform or do you need to get permission from them? Maybe Patrick, you can help us with this.
Okay, now I can unmute. All right. Do you have to inform and get permission from the executor? That really depends on whether the executor is one of the beneficiaries. I'll give you an example. I give everything to my wife, 100%, 100%. So do I need to get permission from her to say that, oh, when I die, you close my bank account, please close my bank account? No, I don't have to, because she's the only beneficiary. And therefore, as long as beneficiary name as executor, you don't need permission. If she needs my permission, I might reduce to 90%, then she know on permission. No need permission. But if the executor is not one of the beneficiaries, then you should get the permission, because the executor is not obliged to do it for you. It's not a contract. It's not a commercial contract. There's no, offer and, acceptance, you see. Therefore, if you are ever appointing an executor who is not the beneficiary, now not only you need to get the permission, ask for the name and IC number before you put it down in your will. You should also consider, I thought, to be fair, to pay the executor a certain sum of money, because everybody is so busy. If the executor need to spend, let's say 20 hours to do the job for you, to complete the whole estate settlement, wow, it depends, no? If the executor is a CEO or a company, I think you better pay. Unless you think that, no, the executor and I very close one, we all, abang late time, no need. Okay, if you are very sure, then okay, then you don't know. But let's be fair, people are spending time to do it for you. Not only you get permission if it is not beneficial, consider paying also.
Right. Thank you very much, Patrick. And also thank you very much to Felicia for answering some of the questions that we have. Unfortunately, I'm afraid that's all the time we have for tonight, and we do have to carry on with the proceedings for tonight. Now, again, I just want to assure those of us whose question has not been answered tonight, we will definitely be getting back to you in writing, right? So rest assured on that. Now, let me just bring us back to our webinar proper itself. I want to quickly just bring all our attention back to the promotion that we are running for this evening's webinar for every will completed with MoneyOwl, and the terms and conditions are attached below, right? You just have to put in the promo code MOMAIL, MOMAIL, right? And you do get to enjoy a $10 fair price voucher, right? These are our contact details as well below on your screen. So do take note. You can also reach us on any of these channels, right? So strongly encourage for those of us who have been listening in throughout this evening. Thank you so much for your kind attention throughout. I hope that Patrick's sharing has been beneficial and it started to get you thinking about the importance of really writing a will, right? But maybe you feel that it is not a very easy thing for you to, undertake in one sitting. Perhaps you might want to just hop onto the MoneyOwl website, do a simple will up first as an interim, and as and when you do feel there is a need for you to maybe consider other clauses to add in, then maybe you might want to visit SimplyWills. So there are many options available, right? Be it a simple will, be it a complex will, the options are out there. The important thing is for us to really take action, right? And I hope I can encourage all of us to take action after this evening session. And I hope that this little promotion can get us and help us get started as well. So again, once again, do scan this QR code. Do take note of the promo code, and this promotion will be ongoing for a period of time. Do take note of the details to get in touch with us if you still have further questions as well. Now, before we end off today's session, maybe just spend a couple of minutes, right? For those of you who are still with us, right? Do take some time to let us know what you feel about today's session. And if you have any feedback for us, it will be really helpful to us. And if you could just leave us a note. And thank you very much once again for everyone who has been staying throughout this evening's session. Hope that this was a beneficial session for all of you. Now, we hope to see you again, and we hope to be of service to you. And let's keep in touch again. Thank you, and have a great evening.
Thank you for having me, Albert.
Thank you, Patrick. And may I
Thank you,
also
Patrick.
may I also add on to what Albert has said? There's a reason why only 87% of people have not written a will. Those people tend to procrastinate. And one of the challenges is it is complex. A lot of us will be thinking, what to give, who to give, how much to give. So, and then that could take you like weeks or even months or years to think through. So that's the reason. But life is uncertain. We really do not know what's going to happen between now until you really write the will. So why not take advantage or take this opportunity to just put in a simple will first with using our MoneyOwl will writing platform. And then at least it saves your family the trouble of going through the administration process, which is a lot more complex than the COVID process. All right. So thank you very much, everyone, for coming in, for dialing in. Thank you, Patrick.
Bye-bye. See you again.
Thank you. Bye-bye.